Hello again. This is the video lecture for Chapter 3, Tort Law. Tort is a strange word. I will admit to you that when I went to law school, I had never heard of the word tort. Sounds like a French pastry or something like that. But what tort law is that it was created to compensate those who have been injured by the actions of another. This is entirely within the category of law that we know as civil law. So if you'll recall, when we were talking about the court system and sources of law, we divided the law into criminal law and civil law. And criminal law, of course, involved any violations of statutes that establish crimes where the state or the federal government was the plaintiff and the person who committed the act was the defendant. In civil law and in tort law, the plaintiff is either an individual person or a company, and the defendant would be an individual person or a company as well. So this is the category of law that includes suing each other for automobile accidents or trespass or damage to property, things like that. So any actions that violate the rights of another person or another company can be a tort. They're not as specific as criminal statutes because they involve, it would be impossible to kind of legislate and lay out every action that could possibly harm another, or every action that we do that's careless that could result in harm to another. So tort law focuses a little bit more generally on what are the responsibilities of the person who committed the act, what degree of care should they be required or expected to exercise under a given set of circumstances. And those are some of the main concerns of tort law. So this chapter is divided into a category of, first we're going to look at intentional torts, and those are the torts that require an intentional act in order for the person who committed the act to be liable. In criminal law, to go back to that distinction, we talk in terms of someone being guilty or innocent. In tort law, we talk of someone being liable or not liable for the injury that their actions or their non-actions or their negligence has caused. And so we're going to look at intentional torts, and then we're going to look at the whole area of unintentional torts, which is the doctrine of negligence. And then we're going to look at a special subset of tort law called products liability law, which has great application in business law. Before we get into the different types of torts that we will find in the book, and I will note to you also that the book is just noting for you a few of the torts that are out there. This chapter does not intend to lay out every single type of tort that there is. That's an exhaustive search again. This is another example of an area of the law that we treat with one chapter in the book, but a law student would be expected to spend an entire year just on this subject. So we were really just kind of hitting the high notes and giving you an idea of what tort law involves and again, what the main principles are behind it. In tort law, in order for a plaintiff or a person who's been wronged to have a claim, one of the things that they'll have to be able to show the court or the jury is that they've suffered some sort of damage as a result of the wrongful act. So if Johnny walks up and takes a swing at me and I duck and he doesn't hit me and I've suffered no damage, then he's not going to be liable in tort law for his act of swinging at me because I don't have any injury or any wrong that needs compensation. So damages are a big part of tort law. If you are going to be a plaintiff, then you want to have a large amount of compensable damages where the money is. There are two types of damages, really three types of damages the book talks about. Compensatory damages are those damages that you can quantify. Think of a car wreck case. Somebody rear ends me. I have hospital bills. I have physical therapy bills. I have the damage to my vehicle. Those are all compensatory damages that I would seek from the person who ran into me. They're quantifiable. General damages, on the other hand, are awarded by courts and juries for those damages that we can't quantify. Pain and suffering, there's no way or formula or calculation to quantify that. Loss of consortium, loss of reputation, disfigurement, loss of use of a limb. Maybe I can only lift my arm up to here from now on. How do we go about finding a way to quantify that? This is an area where you will probably, if you've heard of the word tort before, you've probably heard it as part of the phrase tort reform. What that means, that's in the news a lot, and it's not so popular right now, but every once in a while it'll flare up, where legislatures are faced with trying to put limits on general damages. So even though we can't quantify something like the loss of use of an arm, mainly the insurance companies don't want juries to be able to award crazy verdicts for the loss of use of an arm. And so some states have sought to say, okay, well, arms are worth $300,000, legs are worth $500,000, eyes are worth $1 million, and I'm making that up, but that's the general idea. And so there's a pretty healthy debate on tort reform on whether or not we need to have a little bit more certainty in what damages are for these non-quantifiable things, or if each person should have the right to have a jury or a judge decide what their loss is worth in the context of their life and their loss and their circumstances. Tort reform will get a lot of publicity and get a little more traction every time there's a jury award that seems out of proportion to the damage sought, and then sometimes it'll go away for a little while. Again, that's not a topic that's really come up a whole lot lately, but you may see that from time to time. So that's compensatory damages, special damages, again, the ones you can quantify, general damages, the ones that you can't. Those are both subsets of compensatory damages. And then you have a category called punitive damages. And these are not given to compensate the person who's been wronged. They're given to punish the wrongdoer. You'll see them much, much more often in cases involving big companies in order to deter them from doing the same thing, and then to deter other businesses, other companies who are in the same line of work or sell the same products to not engage in the same activity that the punished company has. When it comes to large corporations, money talks. So if we have a corporation where they're going to do just a cost-benefit analysis and say, well, we're going to put this product out. It may be a little dangerous, but we may get sued from time to time. But our damages that we're likely to get are going to be less than the profit we're making from doing this. And so they might say it's worth it to us to put this product out there that's a little dangerous, because in the long run, on the bottom line, we're going to make more money. And so that's where punitive damages can come in to really deter a company and then other companies from taking risky actions or making decisions that would put consumers at risk. So you will see those very often when conduct is particularly egregious or reprehensible. A good example of that is in the case of Libel versus McDonald's, which is one of your assigned readings, and that is the famous McDonald's coffee case where the lady sued McDonald's for their coffee being too hot, which at first blush might sound ridiculous. But I think when you read the article, you'll see that McDonald's knew that their coffee was too hot, and they pretty much just didn't care. And some of the attitudes of the McDonald's executives that came out during that case really, really hurt them when it came time for the jury to award damages. And so even though it was easy to quantify Ms. Libel's damages for compensatory damages, she had hospital bills, she had surgery bills, and so she was was compensated for those. But then the big part of her verdict was the punitive damages against McDonald's. That's where the millions of dollars came into that case. So those are the types of damages that we'll be looking at. We're also going to look, as we go through, there will be defenses to each tort. And so just because someone has committed an act that might be classified and might qualify as a tort, there are some circumstances where the act that caused the injury was completely defensible and would absolve the actor of liability for having done those actions. So we'll look at those as well. The first category we're going to look at is intentional torts against persons. And of course, this sounds pretty basic, but I don't want to lose in all this the fact that in this category of torts, an element that has to be present is intent. The person who committed the act had to mean to do it in order for them to be liable for an intentional tort. It can be transferred. An example of that is that if I take a swing at Johnny and he ducks, and I end up hitting Ricky, who's behind Johnny, I'm still going to be liable in tort to Ricky because I did intend to swing and hit. It's just that my intent was transferred from Johnny after he ducked to Ricky. So that's just an example of that. The first category of intentional torts to persons is assault and battery. We often hear these together, and we tend to sometimes think of these as the same thing. We picture an assault. Our idea of an assault is some sort of beat down of a person of some kind. But the distinction between an assault and a battery is the actual physical act of touching. You can see I can't point, that's my bad dog right here in the background. And she's banished to the outside because she's misbehaved tonight. That's bad Georgia. Okay, so back to assault and battery. Assault is an intentional, unexcused threat of immediate, harmful, or offensive contact. So if I pull a gun on you but I don't shoot, if I've placed you in reasonable fear for your safety, then I have committed the tort of assault against you. If I swing and miss, and that swing and miss puts you in fear for your safety, then I've committed the tort of assault. Battery is an extension of assault in that it is an offensive, unexcused, harmful touching, physical contact with another. So if I swing and intend to hit Johnny, and I do in fact sucker punch him in the face, then I've committed both assault and battery at the same time. Damages would obviously be for any physical harm, any medical bills, or anything that resulted from the assault or the battery. There are, as we talked about, there are certain situations where there are defenses for every tort. The defenses to assault and battery are self-defense and defense of others. So if Johnny comes at me and I injure him because I put my hands out to stop him, and my fingers go in his eyeballs, like that. My fingers go in his eyeballs, then I have technically committed battery on him, but I would not be found liable if I can prove the defense of self-defense. False imprisonment is another intentional tort against a person that you'll hear about sometimes. It is the intentional confinement or restraint of another without justification. We had a noteworthy, newsworthy case of false imprisonment locally where a bonding company had a bond. They had put up the money for a bond for someone that was arrested for a crime, and the person did not show up for court. And so the bonding company went out to look for the person who'd skipped bond, and they got the wrong person. And it resulted in that person being incarcerated for a period of time. And it was a case of mistaken identity. And so in that case, the bonding company ended up facing a tort case for false imprisonment and they ended up being found by the jury to be liable for that, and they had to pay some damages to the to the plaintiff who had accused them of false imprisonment. And that's a good example of a case where you might have general damages. It'd be pretty hard to calculate or figure out what compensatory damages would be for being jailed for a couple of days. You may have obviously loss of work or something like that, but loss of freedom is hard to put a price tag on. So that is false imprisonment. Intentional infliction of emotional distress points to you if you've ever heard of this tort before. It's uncommon, and it requires that the person committing it engaged in some sort of outrageous conduct. And of course, it has to result in the emotional distress of the person that the conduct was against. And it can't be it can't be protected by free speech. So it has to be something that is so outrageous and causes so much harm to someone that it has just inflicted emotional distress, which again is going to be a category where you're going to have general damages because emotional distress is very hard to quantify. The next intentional tort against a person is defamation. Defamation is when you hurt someone's reputation wrongfully. There are two different types of it, and it depends on how it's communicated. If you slander someone, that means that you have spoken false statements about them that harm their reputation. If you commit libel, that means that you've put in writing false statements that are harmful to another. It's the same tort, it just depends on how it's been communicated. In order to prove a case for defamation, you'd have to have a false statement of fact. The statement has to be about the person who's suing, intend to harm their reputation. It has to be said to somebody other than the person who's being defamed. So if Johnny and I are alone in a car and I say horrible, vile, untruthful things about him, I can't be found liable for defamation because that was not published meaning spoken or written, to another person. If I call Johnny, if I accuse Johnny of serving rat meat at his convenience store in front of other people, and that is untrue, then I could be found liable for slandering Johnny because there was somebody else, a third party there, that heard that. So I like to use my example of Johnny Swanson, and he runs Johnny's One Stop, and his arch enemy is Ricky, and he's on the catty corner block, and he owns another convenience store, and they go at it all the time. So if Johnny prints T-shirts that says Ricky's One Stop sucks, that is not defamation because it's an opinion. So it has to be a statement of fact. If Johnny, flies a plane over Ricky's store with a banner that says Ricky serves rat meat in his hot dogs, then that certainly is defamatory. Again, there has to be some sort of damages involved. So in my example, Ricky would have had to have shown that Johnny's flying the banner over there with the rat meat accusation affected his business or affected his reputation as a businessman, as a safe place to buy convenience store hot dogs, if there's such thing. And so there do have to be some damages. Defenses to defamation are, we've already talked about one, which is truth. Cannot be liable for defamation if what you've said is the truth. And so if Ricky has been arrested for forgery, then Johnny can walk around all day long and talk about how Ricky is a convicted forger and can't be trusted, and he cannot be found to have committed defamation. Public figures have a different standard to prove. example I like to use in that is the, like the tabloids, National Enquirer, and that sort of thing. In a case for defamation against a public figure, the person who made the offensive statement must have done so with the intent to harm the person. So it's a much higher standard for a public figure than it is for an ordinary citizen. The public figure has an extra element of malice that they have to prove. Another interesting wrinkle in defamation is illustrated by the case that you were assigned of Dykstra versus Darling. And in that case, the parties were ex-professional baseball players who were teammates in the 80s. And one of them, Ron Darling, wrote a book, and in his book he said he accused Lenny Dykstra, the plaintiff, of being a racist, of being a homophobe, of being a misogynist, and accused him of saying some really vile and really reprehensible things during baseball games. And in that case, it's a New York case, and in that case, the New York court found that Lenny Dykstra's reputation was already so bad that there is nothing that Darling could have said that would have damaged it. That is called the libel-proof plaintiff doctrine, and that case is a good example of that. That, as you might imagine, is a pretty rare defense to a defamation action, but it was a successful one for Ron Darling in that he sold the court on the fact that Dykstra's reputation was already so bad that really anything else that anybody said about him would not be actionable. Some more intentional torts to a person: invasion of privacy and appropriation. We can't intrude into another's affairs or seclusion. We can't get in their home. We can't hack into people's accounts and steal things. We can't publish things that would place a person in a false light. A newspaper can't publish an article about a pedophile and then put a picture of an ordinary citizen next to that story in a way that makes it look like the pedophile story is about the picture of the person, even though it was for a separate story. Johnny can't put a picture up or put a poster up on his convenience store window that says "Beware of coronavirus" with a little arrow on it, and then paste a separate picture of Ricky next to that. That would be false light. Public disclosure of private facts. I can't go in and steal pages to your diary and then post it to Facebook. And then appropriation of identity is also an intentional tort that is an invasion of privacy. We can't use other people's pictures or images without their permission for commercial purposes. So I can't take somebody else's picture and make it be an advertisement for whatever product I'm selling. Fraudulent misrepresentation. That's an intentional tort because, again, it involves the intent to defraud someone. So it has to be done for personal gain. The elements of fraud are that the person committing the fraud has to have made a misrepresentation of facts with the knowledge that they were false, or else a reckless disregard for figuring out whether they were false or not. The statement that's fraudulent has to actually induce the other to rely on the misrepresentation. The reliance must be justified. So if I'm a salesman and I represent to you that this product is safe for a certain use, and I know that that's not true, then I have intentionally made a misrepresentation. I want you to rely on that because I want you to buy it. If you do buy it, then you have relied on my misrepresentation. And if I'm a salesman and you're a regular customer, then your reliance on my representation is reasonable. You have to have suffered damages, so there has to be something that has gone wrong that's compensable to the fraud, and then there has to be a connection between the fraudulent misrepresentation and the actual injury suffered. If I make a misrepresentation about whether something is proper for a use, but you injure yourself using that product for a totally different use than the one that I misrepresented, then we don't have a causal connection, and fraud would not hold in that case. Abusive or frivolous litigation is another area of an intentional tort against a person. Our court system obviously is not designed to be used by people to harass other people by filing multiple lawsuits that don't have any merit or aren't based on fact, or even once you have a lawsuit going, if you do things that are harassing in nature, that are only used to really damage another person and not further your case, then you could be found to have committed the tort of abusive or malicious litigation. Wrongful interference is another category of intentional tort. If someone has a contractual relationship with another, think employee-employer, and you know that, and you induce the person to breach the contract, then you have committed wrongful interference with a contractual relationship. There's also a tort that's a cousin of that called wrongful interference with a business relationship. And that says that an individual cannot interfere with another's business to gain a share of the market. And it's an important distinction between wrongful interference and competition. True competition is perfectly legal. It can cross the line and become wrongful interference if it's predatory behavior, and if it is if it goes beyond the bounds of what we would consider a normal fair game competition between businesses. All right, so that kind of wraps up just a brief survey of intentional torts against person. Again, the things to remember in that is that the actor has to have had the intent to cause the harm that was actually suffered, and the person who suffered the harm has to have some sort of damages that are compensable in order for them to impose liability on the actor. Now we're going to look at intentional torts against property, and that's exactly what it sounds like. It is a wrongful act against the property of another. Probably the best example and best known example we have of that is trespass to land. So if you are on somebody else's land without permission, or you cause anyone or anything to enter onto the land, or if you remain on the land even after having permission, and after that permission is gone, if you remain, then you can be a trespasser. You don't have to have damage to the land in order to be liable for trespass. Property damage is usually the most compensable form of damages in trespass. You know, if I've trespassed on your property by turning donuts in your field, then those are obviously compensable through the court system. There are some defenses to that. If a person is trespassing in order to rescue another, then they could be that could be a defense to trespass. We also have a tort called trespass to property, and that sort of is a little bit confusing because we think of trespass as really just the physical act of going onto somebody else's land. But if you unlawfully harm another's property, or you unlawfully interfere with that person's property rights, then you've committed trespass to personal property. Conversion is when a person wrongfully possesses or uses the personal property of another as if it were their own. And these kind of go hand in hand like assault and battery. If I see a backpack on a table and I think it's mine and I take it, then I've committed trespass to the personal property of the rightful owner of the backpack. But then by keeping him, I've committed the tort of conversion. Interestingly, it is not a defense to conversion if you just make an honest mistake. So if I thought that if the backpack was identical to my backpack, it just turned out that it wasn't, then I would still be liable for the tort of conversion. This is the same theory that the courts will use to impose liability on someone who buys stolen goods. they didn't know that the goods were stolen, but if they should have known or should have suspected that they were stolen, then they could still be liable to the original owner for the tort of conversion. Unintentional torts. So that concludes the intentional torts section. Unintentional torts is the whole idea of negligence. It is a huge principle in so many parts of the law. And negligence is the idea that we as citizens and companies as fictional citizens have a duty to act with reasonable care in all that we do, so as to not unreasonably injure another person. So the easiest example, just to start this out from a real basic perspective, is I'm driving my car down the road. I have a duty to operate that car with reasonable care, to observe the speed limit, to not be on my cell phone, to be paying attention to the road, to being alert for road signs or pedestrians or any other dangers that come up. So if I am looking at my cell phone and I mow down an old lady crossing the street, then I have not upheld my duty to drive the car with care. We call that a breach of the duty. And so in that instance, even though I didn't mean to mow down the old lady, I'm still liable because I've committed the tort of negligence for not operating my car with a reasonable standard of care. And if you think about it, negligence is absolutely necessary to protect people who are harmed by the careless actions of others. There's no way to write laws that would cover every single instance of how somebody should behave in every set of circumstances. They're just not possible. So what the law does is it just says whatever you do, you have to do that with a standard and the exercise of a reasonable care. A reasonable care doesn't mean the utmost care, the most careful you can be. It just means what a reasonable person will be expected to do in that situation. So if we have a case against somebody for negligence, we're going to have to show these things. Number one, that they had a duty of care. And number two, that they breached that duty of care, that whatever actions they took, or whatever actions they did, were in breach of that duty. We're also going to have to prove causation. So it's not enough just that a person acted carelessly. That careless act has to actually be the thing that injured the other person. We call that the cause. And we're going to get pretty deep into causation and where do we draw the line between an act and all of the injuries it may cause on down the line. And then, of course, we're going to have to be able to prove that there were damages. If I have been negligent in driving my car but I don't injure anybody, then I'm not going to be liable for the tort of negligence because nobody can show that they've suffered any actual injury or damages for those. So first of all, let's break that down, the elements of negligence, and we'll start with the duty of care and its breach. So negligence involves, of course, the careless performance of a legally recognized duty or the failure to perform a required act. How do we decide what's reasonable? We, these days, can't agree on much of anything from one person to another, much less what a reasonable standard would be. And if you think about it, where would you actually have to prove whether or not a person's duty was reasonable or not? It'd either be to a judge or to a jury. So it's going to be up to the person who decides the case as to whether the conduct was reasonable. And they're going to take into account all kinds of things. How old you are, any limitations you have, what were the surrounding circumstances? Did the person who was injured also have any fault because they weren't acting with care? There are many, many different factors that can go into what a person would reasonably have had to do. What's reasonable for me to do driving in the rain is not the same as what's reasonable for me to do on a dry, sunny day. It might be okay for me to go the speed limit when it's, the conditions are perfect. Might not be reasonable for me to go the speed limit when visibility is next to zero. So that's just an example of sort of how the reasonable person standard really depends on the circumstances. There are some duties that are sort of kind of automatic. Landowners who operate businesses or invite the public onto their land for purposes, they have a duty to warn anyone of any risks that their presence might encounter on their property. Think when you go to the grocery store, you see the sign that says slippery when wet or wet, use caution. Perfect example of a landowner having to warn an invitee of any dangerous conditions on the land. Obvious risks are an exception. A owner of a ski slope does not have to warn skiers that snow is slick. So things that are very obvious, you're not required to. That's still difficult, though, if you put yourself in the position of a business owner, because what might be obvious to a grown-up might not be obvious to a young child, or might not be obvious to a person who is developmentally delayed. And so that's why you will see sometimes warnings that you think, who would not know that? But if you really think about it, there's I'm trying to think of a nice way to say this so I don't get in trouble. There's a warning for every person, put it that way. And so business owners have to be really careful about that. The duty of professionals is always going to be higher than the duties of an untrained or normal citizen. If I go to the eye doctor to get a splinter removed from my eye, then they're going to be held to a much higher duty of care than if I ask my wife to try to remove the splinter from my eye. So people that have specialized training or are specialists in a certain field, then they'll be held obviously to a higher degree of what's reasonable in those situations. So that is the duty of care, and then we have to have a breach of the duty of care. Those are the first two elements of negligence. The third one was causation. And remember I said that is a tricky element in that the court or the jury needs to know not just did the act cause the harm, but remember this term, was the act the proximate cause of the harm. So the example I like to use is, let's say that I am driving down the street, and I'm a super careful driver, and I sound my horn whenever I think somebody might even be approaching a different way, or there's any potentially situation where somebody might not know I'm coming. So I lay on the horn all the time. And there's no law that prevents using your horn. It's not negligence to use your horn in normal circumstances. But I lay on my horn to warn somebody that I think is not going to stop. And blocks away, an elderly lady is crossing the street, and she hears my horn, and she thinks it's an air raid siren, and that gives her a panic attack, which leads to her having a heart attack, which leads to her dying. Now, did my sounding the horn cause her heart attack? Yes, it was the actual cause of her heart attack, because had I not blown my horn, she would not have had a panic attack and thought she heard air raid sirens and would not have had a heart attack. So there's no question that that was the actual cause. But in negligence terms, the court wants to know if that was the proximate cause. And what proximate cause really means is that is the point that we draw the line as to where an act's consequences are foreseeable. So, is it foreseeable, reasonably so, that if I sound my horn, that a person crossing the street blocks away is going to think that there's an air raid and have a panic attack and have a heart attack? Of course not. That is absolutely not foreseeable. If I drive 90 miles an hour in a 20-mile-an-hour zone, then any damage that I do there is foreseeable, because when we drive that recklessly, it's foreseeable that we could cause some kind of damage. So again, this is an example of where you draw the line is going to depend on the act, the circumstances surrounding the act, the reasonableness of all these interplaying factors. And so the law just has to draw a line somewhere. And the famous case that sort of established where you draw the line is the case of Palsgraf versus Long Island Railroad. And that is also one of the cases that you're assigned to read for this chapter. And in that case, the court decided that that's the one where, this was back in the 20s, and a passenger was boarding a train. The train was already moving. He was running. He jumped up on there but didn't quite make it all the way. So one of the guards on the train pulled him up. One of the guards from the platform pushed him up. And when they were pushing him up on there, they made him drop this package he was carrying. And the package contained fireworks. Package falls, fireworks explode. Way down the platform, the vibrations cause some scales to fall on the head of this lady named Helen Palsgraf. So sort of like the dominoes in my driving story where I sounded the horn and the lady had a heart attack. And so the question in that case was the guard's actions in pushing the man onto the train, was that negligent in the sense that he should have foreseen? Was it reasonable for him to foresee that by pushing somebody on a train, that person might drop fireworks, which would then cause vibrations to cause scales to fall on the head of the lady at the other end of the platform? And in that case, the court said, we got to draw the line somewhere, and we're gonna use the doctrine of foreseeability to draw that line. And in this case, we say that it was not foreseeable that the guard helping somebody up on a train would have ended up causing the chain of events that eventually led to a scale falling on Miss Helen's head. And that doctrine has carried throughout the law until today. It's a very important doctrine in trying to decide, where we draw the line and what kind of conduct is wrongful enough to be compensated for a person who is injured down the line. So, important case for you to give some thought to, and the assignment for week 2 incorporates some questions from that case as well. Some defenses to negligence: assumption of risk. If you know of a risk and you disregard it, then the person is not liable for negligence. If I decide to establish with my buddies a chainsaw fighting league, or we're going to use chainsaws to fight each other every Monday night, then we have assumed the risk of misusing chainsaws. And the manufacturer of the chainsaw is not negligent because they didn't warn us that chainsaws were not appropriate to fight with. If I decide to go climbing down in a mining pit that's off limits, the landowner is not going to be liable for negligence for not keeping me out of there because I knew of the risk and I assumed it when I did it. Contributory negligence and comparative negligence are related defenses. Contributory negligence, and states differ on whether they have contributory negligence or comparative negligence. Contributory negligence means that if the plaintiff was at fault, even 1% at fault, then they can't recover from the wrongful actor at all. That is fallen out of favor in favor of the doctrine of comparative negligence, which means that yes, a plaintiff may have been a little bit at fault, but they were not as much at fault as the wrongdoer. And so the jury or judge is going to have to assign fault between the two, and then they would reduce whatever award they gave the plaintiff by the percentage of fault that they assigned to that person. In the Libel versus McDonald's case, for example, the jury did use the doctrine of comparative negligence, and they decided that Miss Liebeck's taking the hot coffee and putting it down between her legs in the car was a negligent act, and that she was 20% to blame for what happened. So the amount that they awarded her was reduced by 20% because that's the proportion of fault they had assigned to her. Okay, my screen just went off. I think we're still okay. Yep, this is getting long, and I don't want to. You may already be asleep, but if you're not asleep, I don't want to put you to sleep. So I'm going to try to wrap this up. There is an idea in the law called strict liability. And what that means is that there are some activities that are so dangerous that no matter how much care you use, you could have used the perfect amount of care, things can still go wrong. And so in abnormally dangerous activities, the actor could be liable whether they were negligent or not. Like dynamite blasting is an example of that. We could have used all the care in the wing off the dynamite, but if it results in some damage to property, even though we were as careful as we possibly could be, then the doctrine of strict liability might apply, and the actor is liable for whatever damages they caused, even though they were careful. Products liability is a totally separate subset of tort law. So up to this point, we've talked about intentional torts against persons, intentional torts against property, and then unintentional torts, which is negligence. Product liability involves negligence as well as some strict liability concepts, depending on the type of products liability that we're talking about. In the area of negligence and products liability, think of, okay, what is the duty of care that a manufacturer of a product has to exercise? We would expect as a society that they would use reasonable care in designing the products, in selecting materials, in producing the products, in assembling the products, and testing the products. We would assume that they would use care in placing warning labels to inform users of any ordinary dangers. And we would expect them to inspect the products and test components from other manufacturers that they might be buying to put in the product. Products liability law does not require that you are the one who purchased the product. So I could purchase a chainsaw that's defective, and I could let my neighbor, who's my brother-in-law, use the chainsaw, and if he's injured because the product was defective, he still could sue the manufacturer even though he's the one that didn't buy it. And that just makes too much sense. It would be unfair and unjust to require that only people who purchase the product could sue for negligence or products liability. There is, just like in intentional torts, in negligence, there's strict products liability. Many states have this, and they say that, you know what, we're not even going to make you prove that the manufacturer didn't use reasonable care in doing all those things we just talked about, the design, the manufacture, the testing, the inspection. We're not even going to fool with whether or not the manufacturer was reasonably careful. We're just going to go ahead and say that as between an individual citizen and a corporation or manufacturer, who's better positioned or equipped to bear the burden of paying for injuries? And as a society, we've just the courts have kind of decided that, you know, it's really better just to place the burden on the manufacturer, whether or not they were careful, their product caused an injury, and we're just going to say that, you know what, let's don't fool with whether or not they were careful. Let's don't place that burden on individual citizens. We're just going to say if you were injured by a product, then strict liability says that the manufacturer is going to have to compensate you for it. That's not the case in every state, but you do need to know that that is strict product liability is a real thing, and it's the idea that better to have companies pay out money than have individuals not be compensated. I'm just deciding what's necessary to bore you with for the remainder of this lecture. Some defenses to product liability. Again, assumption of risk. If a person knows that a product is defective and they use it anyway, then that might be a defense that the manufacturer could use against that person. If a person misuses a product, if it engages in using the product in a use that's not intended, then we don't think it's fair that the manufacturer should be liable for an injury caused. And that's where you see a lot of warnings come in, that, you used it for an unintended use, and the reason that you know it was unintended is because we put a warning label on there that told you that any sort of use except for what we lay out is unintended. And there's also the defense of comparative negligence and contributory negligence that also applies in products liability. And so also if the injury is the result of just a commonly known danger, then that might be also a defense to a products liability case. So I understand this was a long lecture. If you sat through it, I appreciate that. Torts is just a really important area of the law that I think a lot of average citizens don't understand the framework of. And so I do think it's important for any person in the workplace, any business owner, entrepreneur, any employee, to know what consequences they may suffer for their actions or for their carelessness. So it's just a good thing to sort of be able to analyze what your exposure is to different kind of risk, to what your potential losses could be if you were sued, and then as to what kind of steps and what kind of precautions you would want to take as a business owner or as an employee to limit or minimize the risk of someone. This is the lecture for Chapter 4 is intellectual property. The reading assignment is not very long for Chapter 4, and that chapter is pretty straightforward, so I'm not going to lecture on Chapter 4. This will suffice for both of those chapters. If anybody, as always, has any questions about a specific aspect of torts or of intellectual property law, by all means give me a call or shoot me a text. Also remember that we have the supplemental resource of thebusinessprofessor.com, which you'll find in the syllabus and resources tab of the content. And again, that person breaks down different topics in business law into really short videos that I think are helpful to just reinforce some of the basic ideas. So good luck with these chapters, and I will see you next week.